Every Tuesday, we do bring in immigration updates. And what do we have today to discuss, Emily?
Today, we're going to start off talking about green card holders and whether it is safe for them to travel outside the US right now. Although the core rules regarding lawful permanent resident travel really hasn't changed, the current climate definitely has. There's more scrutiny. So we want people to be aware of the issues and plan their travel with that in mind so that they can have a smooth travel in and out of the US without having any issues for their green card. We're also seeing a new trend with L1B visa applications at the consulate under blanket L approvals. These are for large multinational companies that kind of have advance approval of all of the qualifying relationships of their different locations. And, just within the last week or two, it seems like a switch has flipped in how officers are adjudicating these, and they're wanting a lot more specialization, a lot of more scrutiny is happening of those. So we'll talk about that and what people should be aware of. And then updates on DUI or DWI, driving while intoxicated, how that impacts non-immigrant visa holders or green card holders. Lastly, citizenship. Big news today was that the government is bringing back its plans to do these neighborhood checks for people who are applying for citizenship. Back prior to 1981, they used to make you bring two witnesses with you for citizenship. They eliminated that when they changed the law in 1981, and then instead have required neighborhood checks to be done. Those were done kind of routinely up until 1991, and then they decided they didn't need them anymore. So now we're going back to 1991, and USCIS may be looking at what your neighbors have to say about you, what your business associates have to say about you before they'll approve your citizenship. So is now a good time to apply, or is it better to wait until we have a new president to apply for citizenship?
Coming to the first topic with the green card holders traveling outside the country, though, um, I would say that the fear is a little bit more than the actual truth. So if somebody is just a normal Tom, Dick, and Harry, and they are just traveling outside the country for a temporary trip, let's say 2 months trip or less than 3 months trip, I don't see any problem in it if they have not traveled for more than 180 days on a single stretch. Not aggregate. Like, for example, if somebody is traveling every year, 2 months, every year, 2 months, and they have covered more than 6 months, that's not what I'm speaking. I'm speaking of if somebody has traveled more than 6 months at any given time, they definitely need to check with a lawyer. And if somebody has any criminal records, I'm not speaking about traffic tickets, regular traffic tickets. But if you have a DUI or anything like that, I definitely want you to check with an immigration lawyer what is expected for you. And before you travel outside the country, definitely check with them. But for the 95 to 98% of the people, though, we don't see any problem whatsoever at all for people traveling outside the country. People also ask me the question, if you travel outside the country, do you have to wait for 5 more years after you travel outside the country? No, that is not true. In general, for the people who get the green card, it's 5 years from the time you get the green card, not from the time you traveled and came back into the United States. Of course, there are some exceptions where people are eligible within 3 years. If you are married to a US citizen, that's a different issue. But in general, 5 years is a timeline. And of course, USCIS allows to file the N400 application 90 days before the 5 years. So you can do so. So definitely for 95% of the people, we do not see any problem whatsoever at all, only if you have traveled outside the country for more than 6 months, or if you have any criminal history, then you should consult an immigration lawyer before you embark on a journey. Emily?
What about the ability of CBP officers to access people's electronic devices, review what's on their phone? Should people traveling as green card holders do any activity to minimize that, or are they safe traveling with their electronic devices now?
I don't see any problem for the people who are green card holders or traveling. I've never experienced, I've never been consulted, spoke with any persons who have any issues who are traveled on a green card holder. People also ask me the question, Emily, that if I'm politically opinionated, will that create any problem in my travel? Now, if you are criticizing Trump or up and praising Biden administration, I don't see any problem whatsoever at all. It's a hype that has been created. I am not a Republican. I'm not a Trump fan, guys. But if you just criticize Trump administration, you're a green card holder, you forward something, you will have no problem whatsoever at all in your traveling. Now, there are some issues. If you are supporting Hamas kind of terrorist organization, or if you're supporting ISIS, which is a terrorist organization, and you are posting about them, definitely that may cause a concern for your travel to come back into the United States. So otherwise, if you just have a political opinion, now I don't like Republican Party, I don't like tariffs imposed on India, I don't like tariff imposed on China, or maybe you want more tariffs imposed on China, whatever those kind of things, we don't see any problem. Emily, going back to the first topic of the electronics, do you what what is your opinion on though that if people are traveling with electronics? Of course, I don't know of anybody who doesn't travel. Everybody has electronics right now, and right now, cell phone has almost the entire life of
Mhm.
anybody.
Right. Yeah, and I think there was some data that came out recently of the actual number of electronic devices or people that they have searched the electronic devices on, and they the way the statistics sound is that it's drastically increased over the last 5 years or 10 years or whatever the time period was, but the actual number of electronic devices they're searching is still quite low. So I really think it is you know triggered by other things that they're maybe have in their background, or other things that they're doing, maybe places they traveled to that aren't a good idea to travel to. I think those are what would be triggering any kind of device search for most people. I think very few people are actually dealing with that issue.
With regards to essay, I want to answer this question right now. He has only DU. He'd never have any DUI. He had some minor car accident with no fault, accident at fault. Will it create any problem in his travel? And he is not having a job. His mother is concerned that he will have trouble. I don't see any problem whatsoever at all for you to travel, essay. Please, if your mother is not doing good, you are a green card holder, you can travel. I don't see any problem at all. You can travel. Tell your mother that I told you that it's not a problem and you can travel. You are a green card holder. Whether you have a job or not is irrelevant for you to travel outside the country. Since even though you are at fault at a car accident, everything was been cleared right now. So I don't see any problem in that. I hope that the travel the accident has not created any major physical injury to the person. If that is no physical injury to the person, though, I don't see any problem in you traveling outside the country.
All right, moving on to L1B denials. We saw this during the previous Trump administration, really just scrutinizing more heavily that specialized knowledge aspect. And so, for large companies that have the blanket L approval, they get to skip filing anything with USCIS and they go straight to the consulate. So, the consulate will decide whether the person has specialized knowledge or not. And the um, level of scrutiny is a little bit higher at the consulate. With USCIS, you have to prove it by a preponderance of the evidence, but the consular officer is looking at, is this clearly approvable as an L1B visa category? Now, the funny thing is, when we're not in the Trump administration, it's usually easier to convince a consular officer that something's clearly approvable compared to convincing USCIS that an L1B is under the preponderance of the evidence standard. So for a lot of people, we would send them to the consulate because it's easier. There's no RFEs. You don't have to bring as much documentation. But recently, there have been quite a few reports of L1B denials It's just, and the questions asked are, what makes you so special? Why your job? Why can't they hire a US worker for this job? So they seem to be, again, really focusing on that American worker first mentality and consular officer deny first, ask questions later mentality. We're not sure if maybe there was some sort of communication issued to officers recently to make this mental shift. We have done a Freedom of Information Act request, so we'll see if and when we get any updates from that. But for now, I would say for L1Bs, even though they can qualify by just have working for the company for 1 year out of the last 3 years, that might not be enough, even though it meets the standard. It's not enough for you to gain that true specialized knowledge of the inner workings of the company, and that even though it doesn't have to be proprietary knowledge, that seems to be what the consular officers are looking for. So definitely make sure you're well prepared for your interview, able to clearly articulate what makes you special, why they couldn't hire someone else for this position, kind of have an elevator pitch to go in, and just be prepared for those kind of questions.
For those people who are in USA who intend to go for stamping for the extension of L1B, we definitely recommend to get that done here in the United States. We also have a question from an L1A individual who is asking whether extensions are becoming a little bit tougher. The answer is yes. We're having some issues with extending the L1As. What we strongly recommend people is to get the result before the I-94 expires. Because if by any chance you get the denial, though, it doesn't prohibit us from filing one more extension. Let's say your H1 L1 is expiring in December of 2025, and we file an extension, either L1 or L1B, and we get the rejection in October or November or even December. We can file one more extension for you, even though we got the denial. And we can, based on the denial, what we get, we can improve upon on your particular job duties. So definitely getting a result before the 94 expires is a very good thing. DUI, are there any new developments in the DUI? And people are scared about the bill that is passed in the HR 875. Recall it's passed in the House and it's been received by the Senate. Based on that bill, what it says is that if you have a DUI, even if it's before the law is passed, then you're completely barred to coming back into the United States. And there are issues for the green card holders also for this. Definitely, this kind of bills we have seen many times. They don't normally get through the Senate, though. So we're not giving that serious concerns at this point of time. A DUI without involving an accident at this point of time. Um, what what is the difference between Trump administration and before Trump 2.0 to before is that definitely we are noticing that the people who are involved in the DUI, if you file for an H1B extension, H1B transfer, H1B amendment, they are asking to come for the biometrics though. For those people who are going for stamping, we haven't seen any denials just because they have a DUI at this point of time. But the only thing that we have seen is that there is an increased biometrics. But we haven't seen the extensions denied, though, at this point of time of anybody who has it. That's the only major development. That is, we advise everybody to use Uber or whatever services, Lyft, whatever you have it. We definitely don't encourage anybody to drink and drive. Do not do that thing. It's not what we see so many cases that get into trouble. It's not worth, believe me, that $50, $100 that you spend on the Uber or Lyft or whatever you spend it is definitely worth for you. Don't get involved in it. Anything else on the DUI updates, Emily?
Yeah, I think we are likely to see that looked into more carefully with naturalization applications, as well as part of that good moral character, as well as these kind of new extension or change of status RFEs saying that we're going to potentially use our discretion to deny a change of status or deny an extension of stay. And so if there is a DUI in the background, it may need to be dealt with differently than what we would have to do before, to show the positive factors, the positive equities of why the extension or change of status should be approved. I don't think we've seen any denials up until this point on that discretion yet. So hopefully it's just, not hopefully, but seems to be more just a scare tactic than anything else and not something that has been implemented yet.
If you are eligible to apply for citizenship, is the right time for you to apply? Absolutely, it is. Unless you have some criminal record or if you have a DUI, sometimes a good moral characteristic, we may want you to wait for 5 years after the incident, though. So there are some issues if you have any criminal records, whether you should apply or not. There are some issues if you have a travel for more than 6 months travel outside the country and as one single stretch, we may want you to discuss with an immigration lawyer before to check. But in general, 95% of the people that fall into the category of normal Tom, Dick, and Harry who don't have any criminal record except for minor traffic speeding tickets. And for those people who have just traveled outside the country for less than 6 months at any given period of time, at one single stretch. I mean, they might have traveled 2 months, 2 months for 5 times. That's perfectly okay. For those people, we strongly advise apply right now. There is no reason for you to delay the citizenship. There are a lot of people that ask questions with regards to what will happen to my Indian property. I am a licensed lawyer in India also, and your Indian property is fine. It will be on your name. You can sell it after you become a US citizen. I don't see any problem. With regards to purchasing new agriculture property, there are some restrictions. Are definitely restrictions. There are ways to get away on those things too. If you want to, you can consult a lawyer in India or a lawyer here who has license in there, where there are ways to get around it too. There are many ways to get around legally. I'm speaking about where you can convert the agriculture property into non-agriculture property, and then you can buy it. So there are many different ways to do it. So, and if you're already having an agriculture property, you can still sell it. It's not a problem. It's only buying new agriculture property. There are some restrictions in India, but as such, I recommend all the people to become a U.S. citizen as soon as possible. If you're international, if you're considering going to politics, that's definitely worth for you to maintain the Indian citizenship. Otherwise, if you are going to stay in the United States, you're perfectly all right. People also ask me questions that once I take the citizenship, can I go to India and stay there for 10 years? Will that be a problem? India does allow it. It has an OCI. It doesn't have any problem. You can stay in India however long you want to. I don't see any circumstances where you have to give up your US citizenship. If you live in India, I don't see any problem in it at all. So definitely, if you are eligible for the citizenship, we strongly recommend you file it. You can file it online. They have given this nice opportunity to file an online N400 application. So please do it. Any questions on it, Emily? Any suggestions on citizenship?
Yeah, we had last week or the week before the policy memo update saying that they're going to use a more rigorous and holistic standard for good moral character, wanting to see people's positive contributions to society, not just the lack of negative factors. And then we have today's kind of advance announcement about these neighborhood checks with that. So yes, they're talking about it a lot, but for most people, I don't think it really impacts them. Maybe the biggest impact, you have to provide a little bit additional documentation of your positive contributions or potentially testimonials from friends and family and neighbors and that sort of thing. But I don't see them using these new policies as a way to deny most people's citizenships. I think again, it's more a fear tactic to get people not to apply than anything else.
Anything else, Emily, before we do question and answer?
Nope, we can go ahead.
A question which is coming from Praveen. He has a child who is 19 years old. The child got admission to college. When is the right time to move to F1? Uh, so for H4 people, they cannot take the internships, though. They can study, but they cannot take internships. If they want to take internship, they need to move on to F1 visa. If they want to work in the summertime, they need to move to F1 visa. But otherwise, they don't need to move to F1 visa. However, before they turn 21, they definitely need to move on to F1 visa. We also want to have 1 year of education to be done at F1 because there are some restrictions which a DSOs may put it that if you don't do 1 year of education in the F1, which is not exactly true, but anyway, they may want to implement that 1 year before. I definitely want. So if you're graduating, let's say in June of 2027, I definitely want you to get an F1, get into F1 by August of 2026. So 1 year before, 2 semesters before, you need to get into the F1 visa. Now we have a premium processing, you can use it to get it done. And there are some people who want to do internships that definitely you need to move to F1 visa. There are some people who want to do summer jobs that they definitely need to move to F1 visa to get into the summer jobs.
Sai says if you have an I-140 approval from company A from 10 years ago as a software engineer, and now you've changed to company B and your job duties are as a manager, will that be a problem to port or retain the priority date? No problem at all. The only factor that they look at in determining whether you can retain an old priority date on a new filing is, was that old I-140 ever revoked due to fraud or misrepresentation? That's it. If it was revoked because it was withdrawn by the old company, no problem. There's no looking into what the job is, what the category is. You can port between EB1, 2, or 3. So yeah, whatever your job is now compared to what it was then is completely irrelevant for porting a priority date.
Manoj's wife has an accident, and a citation was being given. She appeared in the court, and the ticket was dismissed by the judge. No one was hurt. That should not. We may have to mention this to in the DS 160 when you go for the stamping. We may have to mention for the green card application. We have to mention it. We may have to mention this one in the citizenship application. But have we seen this becoming a problem in getting the visa stamping or green card or citizenship? No, I have not seen that as a problem. Even under the current administration, I don't see that they are going to deny your wife citizenship, green card, or a H-1B visa or H-4 visa for her.
Santosh has a question for his spouse and wants to know, is it possible for her to continue working without any issues while her H4, H4 EAD application, I'm assuming renewal, is pending? Um, it depends. There are many cases where she has to stop working. There are a few situations where she can continue working. So yes, there is a 540-day automatic extension of the H4 EAD, but it only works if the H4 has already been extended. So if you filed the H4 extension and the H4 EAD extension together and they're both still pending, you don't have an extended H4 to be able to use the auto extension. Now, you could potentially get it by traveling, either going to your home country and going for H4 stamping based on your already extended H1B, or possibly going to Mexico using automatic visa revalidation and showing your H1B approval extension when you're coming back to get the extended I-94 for the H4. But without doing any of those things, the automatic EAD extension is not automatic because you don't have an H4 extension yet.
Okay. When does a U.S. citizen child can sponsor the parents? The U.S. citizen child has to become 21 years to sponsor. The U.S. citizen child has to become 21 years before they can sponsor for their parents.
Chanta says, do you see any 485 denials with a AOS employment-based interview if the principal applicant has filed a writ of mandamus? I mean, yeah, it can happen. When you're filing a writ of mandamus, you're not asking the judge to tell the government to approve the 485. You're just asking them to make a decision. That decision could be an approval or a denial. Now, does the litigation cause the denial? No, definitely not. We do not see that happen. If there are already underlying factors that would have caused a denial, filing a lawsuit is not going to make them go away. They can still deny the 485. So you need to look into, is it a strong case in the first place to decide whether litigating is going to be a good option or not, or if it's just going to get you a fast denial.
Emily, I want you to pay attention to this one. I want your advice also to the clients. These Indians have a little bit weakness in this one, and they are not good in this. This question is coming from Sunvi. As a green card holder, there was a ticket for not disclosing chicken pickle in 2012, for which he was paid the fine. Would it be a concern for the travel? Definitely, it's not a concern for travel. You can travel. You may have to disclose this information in the citizenship application. I'm not expecting this as a lack of good moral character at this point of time. That's my opinion, though. And I tell all the people, and I know my mom won't even listen to me. I don't know why. Uh, that please don't bring any food materials into United States. If you do, you disclose them you disclose them very clearly in the customs form, and disclose everything what you have, and then see what they are going to allow, what they're not going to allow. Especially chicken pickle, it's illegal to my knowledge. So definitely, what my sincere advice, people, is not to bring it. There were person who was bringing banana. I mean, she was given a banana in the airlines, and she was trying to bring it in. That's not allowed. I know she does not know it, that, but it doesn't excuse though, because there are some issues that happen where an agricultural product was being bought into United States several times, and it destroyed the crops of United States. It destroyed, because there are some bacteria that may come with it, which may destroy the entire crops of United States. I advise not to bring it. Emily, please advise my mom and my wife also.
Yes, please don't bring anything in. And if you do, disclose it. Don't try to sneak it through. It's not worth it. Listen to your son. All right. Santosh says, my H-1B was approved 4 weeks ago, but my spouse and child's H-4 cases still pending. Are there any suggestions on this situation for the current trend? That's normal. Unfortunately, we're back to the unbundling of H-1, H-4, and H-4 EAD. So although sometimes they do all get approved together, sometimes they end up at a completely different service center even. Because now we file everything at a lockbox. The lockbox scans everything and then routes it wherever they want to route it. So you could end up at any different service center, and there's not really anything you can do for that. You just have to wait until it processes. If it's an unreasonable delay, you could potentially litigate it, or you could get the H-4 extended through travel, as I mentioned earlier.
Second.
Sai says H-1B extension was filed in premium and an RFE was issued 1 week ago. How long does it take to receive the copy? And what is the trend on extension of H-1B and H-4 and EAD? It usually takes about a week. I had two issued last week, and I got them both this week in the mail. They do come by snail mail. They're supposed to also come by fax, but we have not been receiving the faxes lately, which is also normal. In terms of trends on extensions, I'm not seeing a lot of problems with them where it's the same company, same employer, same, job duties, nothing changed. Every once in a while, we'll see where they think that maybe the prior approval was done in error. And so for that reason, they're not going to defer to that prior approval. And now they're going to look into whether it actually is a specialty occupation or whether you're actually qualified for the job, even though they've approved you before, which we saw again under the previous Trump administration. But we're definitely not to the point where we're seeing tons of denials every day and shortened approvals and all the problems that we were having during the previous Trump administration. I do think that's probably coming at some point, but has not happened yet.
Um, Pradeep has this question. that can a person on the AOS EAD advanced parole travel outside the country and stay outside the country for more than 6 months? They are the dependent 482 application. We recommend strongly they do not spend that much time. They do come within 3 to 4 months. If they do have plans to stay for more than 6 months, we definitely recommend that you contact immigration lawyer. I would avoid contacting immigration lawyer, have them come within 4 months. That's the best solution. But if you have to and they have to stay there, then definitely contact the immigration lawyer.
Ali says for an I-140 petition, do we need to just submit the two-page perm approval notice, or do we need to also submit the whole perm application that was submitted to DOL? To talk to different attorneys, you're going to get different answers. Even within our office, some of us file it with the whole perm application, some of us file it just with the perm approval notice, and we don't see any difference in adjudication either way.
Um, Used to be an H-1B. Now I'm an F-1. Once I get the job, can I go back to H-1B? 4 years left and continue study. This question is coming from MG from X. Absolutely not a problem. Now, once you got the H-1B, you don't need to be counted on the H-1B again unless you use the entire 6 years. In this case, since you told that only 2 years have been used, the rest of the 4 years can be used in the next 90 years at any point of time, not a problem.
MTS says I'm on an EB3 I-485 and have been scheduled for an interview in the Houston office. Is there anything I should worry about? Are interviews for I-485s increasing for employment based? They're definitely increasing. So there's nothing automatically to be worried about just because you're being interviewed. Very common nowadays, whether even EB1 is being interviewed. They're definitely increasing. We're not seeing really problematic things at these interviews. A lot of questions tend to be about how you got the job, who interviewed you, where was the job posted, which doesn't really make a lot of sense for an I-485. But again, it goes with this whole kind of narrative of the Trump administration that immigrants are bad and taking American workers' jobs. And so they want to see how the jobs were found by immigrant workers.
Question that is coming with K3 that his son is 15 years old. His birthday date is 2015 April. What are the chances for the child to get a green card under the priority draft of April 2015 under EB2 and EB3 of the parent? We don't know at this point of time. 15, he has 6 years. Maybe some time on the I-140 is pending. I definitely would like to have a plan B. So you and your wife, your spouse need to discuss what is a plan B, what is action B. One thing that I notice is that these children who are, they come with very young age into United States. They don't understand the immigration as much as we guys do. Now, I'm not telling they're not smart. They're smart in everything. They are very knowledgeable. They're very good. They're very smart in many things. When it comes to the immigration, though, they ignore it completely. They leave it on the parents, though. They're good in finances. They're good in education. They're good in everywhere. But in this part, we definitely want your kids or teenagers right now to get hooked into our YouTube channel because we have been doing this from past 8, 9 years. Every single week, we cover a lot of major topics. And we need these kids at least to listen once a week, 30 minutes to us. That's what we recommend. We do also have a Zoom call every day. We recommend strongly that once in a while, you guys need to come to the Zoom call. Here, we are only answering the questions what you're posting. There in the Zoom call, every day we do conduct. It's free. We are doing it from 2012. It's been more than 13 years that we're doing that one, where about 50 to 70 people come in there. I do answer live questions there. So there will be interaction in the questions. It's not like you pose a question, I answer. There's no interaction here. But in the conference call, we do have an interaction. In the Zoom call, we have an interaction. The link is provided there where you can see the timings and how to attend the Zoom call. The link is provided there. So you may want to have these kids attend these Zoom calls too. Have a plan B. Yeah, there is a chance you may get the green card for this kid. There is a chance you may not. There are high likely chances the kid may not be able to get the green card and they have to swim on their own.
Blue says I'm on L1A. I have an EAD and AP approved. If my L1A extension gets rejected, would I be able to shift to the EAD and AP, or would that L1 rejection also impact the EAD AP? The 485 application has been pending since October 2022. Assuming your I-140 is approved and the L1 extension is rejected because for some reason they decided to look into everything again and they don't think you qualify now, it does not have any impact on a pending 485 or an approved EAD or an approved AP. So you can then switch to start using your EAD to work and you can use your AP to travel. 485 will continue to be pending. There's some risk that if everything in that L1 extension is exactly the same as what was in your approved I-140, are they going to go back and potentially reopen the approved I-140? I think there's a slight risk of that, just because the requirements for both are so similar that if they don't think that the requirements are met for an L1A, then maybe they should not have been met for the I-140, but that doesn't happen automatically. The L1 denial would not impact a 485 or an EAD or an AP.
This is an interesting question. He has a green card, and if somebody travels outside the country for a period of 2 years, can they apply for citizenship application? The person has applied a reentry permit. I just want to explain what this reentry permit is. Reentry permit allows people to stay up to 2 years outside the country, though. That is allowed, but there is a problem here that you will delay the citizenship, though. So, for example, if you have a green card from 2020 and in 2023 you applied for a reentry permit, and after that reentry permit, you came back into United States on August 26th of 2025. That means you stayed up to 2 years. You know what? You will have to start counting the 5 years all the way again. So that's a problem, though. If you're outside the country for more than 1 year, the reentry permit will allow you, but you're starting the 5 years all over again for the citizenship application. Not only you should not only it's a risk for you to apply for citizenship, you should not even apply for citizenship because you don't want to get a denial of the citizenship. So definitely we want you to contact immigration lawyer. We don't want you to apply for the citizenship. If you have stayed for more than 1 year on the reentry permit, and we don't want you to apply, you should contact an immigration lawyer to make sure when you actually can file. The rule we normally say yes is 4 years and 1 day afterwards you can apply for the citizenship after your last entry into United States where your absence is more than 4 years. But at the same time, there is a lot of documentation you need to require, you need to keep for getting the citizenship, and you need to provide all the documentation when you go for the citizenship.
Sindhu says lost the H-1B job in November 2024, switched to B2, now switched back to H-1B with a new employer. Had my visa stamp with the old employer till 2026. After these change of status approvals, do I need stamping again to re-enter if I travel to India? You do not need to go for stamping again until 2026 when this visa stamp expires. An H-1B visa stamp is valid regardless of what employer you're working for, as long as you have a valid H-1B status and H-1B approval notice. So yes, you can use the existing visa stamp to travel, even though you switch to B2 in between.
Asma is finished her high school in United States, moved to Poland, I guess, and then now she wants to come back to USA. Um, what is to finish and pursue her studies though? The main question is that are you under 21? Are you above 21? If you're under 21, does your parents still have the H1B? If you're under 21, if your parents are still H1B, yeah, you can come back in H4. I don't see any problem. If you either are above 21 or if your parents do not hold the H1B in United States, you have to come back an F1, which is a problematic. It's not that easy for you to get an F1 visa. There are chances they may reject, there are chances they may approve it. But if you are under 21, your parents are here on H1, easy to come under H4. About 21, you have to apply for F1. There are risks involved in getting the F1 visa.
Prem says, is there any issue with traveling outside the US on an H-1B multiple times? I usually travel just twice, but since my spouse and child are outside the US, I may need to travel 3 or more times in a year. Are there any issues at the port of entry? Generally, no. I mean, not just due to the travel, but if you are outside the US for an extended period of time, the port of entry may ask, do you still have a job to come back to in the US? So assuming that you do, you need to have documentation of that, have your pay statements, have a letter from the employer confirming that you're on leave for whatever period of time that you're expected back into the US in order to continue your job. But other than that, you can travel multiple times in and out on an H-1B as long as you have the stamp.
Leah has this question. Our family had a GC interview on August 14th on EB1C. Our daughter was on CSPA. The interviewer said he needs to review if she has to be under 21 when filing or interview date. No update since then. Now, if the child is under 21 and meets a CSPA requirement, she doesn't have to be your child doesn't have to be under 21 on the interview date. Now, of course, the officers are not all well educated to be in the USCIS, though. So they may not be aware of this one. They don't have. I would wait since the interview only happened on August 14th. I will wait until September 14th. If they still do not act on your application, I would sue the USCIS because that's the only way to get the attention, though. When you sue the USCIS, typically what happens is that the judge, will it go to the full hearing? No, normally it does not. They normally go to the officer. Hey, officer, there's a court case file. What do you want to do on it? They will research and they will do whatever they have to, and they will normally adjudicate the application. That's how it works out. And if you're interested in that, Leah, you can contact Stephen Brown in our office. And there is an appointment link. There his schedule is available online. You can block a time that is suitable to you. But I would recommend to wait at least until September 14th to see if it's going to be approved.
Inigo says, I have an EB1A I-140 approved with a 2017 priority date. My H-1B is valid till 2027. Is there any time limit for filing the 485 with respect to the timeline? There is, once your final action date has been current for 1 full year, if you have still not filed the 485, you may not get the next H-1B extension. It becomes discretionary and it's only going to be issued for 1 year if they decide to issue it, and they may not extend it further beyond that.
Uday, he's a strong RSS supporter. I happen to know that organization, was part of that organization once. I'm not, but I was once part of that organization. Will it be a problem if I travel outside the country given my political views? I don't see any problem at all. I'm not an RSS guy right now. At one point of time I was. But I know what RSS is, and I do not see that as a problem at all in your being a member and traveling outside the country on a green card. I don't see that as a problem. Question from Tridev. He has a H-1B approval with company A. The stamping is expiring in 2026. Now, I made this up, 2026 May. He is actually working for company B, which is expiring in 2027. Doesn't need to go stamping if he's coming back while the H-1B stamping validity period with company A. He doesn't need to go for stamping. When he comes back into United States, he has to show the H-1B approval of company B, and he has to tell that he'll be working for company B and make sure that the I-94 online, which is issued based on the company B's H-1B approval. So as soon as you enter into the country, you check it, make sure that the I-94 is issued based on the company B's H-1B. Do not contact immigration lawyer in 2027 and find out, oh, my I-94 expired in 2026, I'm illegal. Don't do that. As soon as you enter into the country, if you feel that there is any problem with the I-94, if it's reflecting based on company A, That should let your antenna up, and you should contact an immigration lawyer at that point of time. There are very, very easy ways to cure. But if you delay it until 2027 and you watch the I-94, you are in big trouble.
Deepika says, does the USCIS count dependents for employment-based green cards? And is it the same for family-based? Is there a way to request USCIS to not count dependents? And can we request USCIS or Congress? They do count dependents towards the employment-based green card number and the family-based green card numbers. So when we say every year there are 140,000 employment-based green cards, over half of those go to family members. That does not appear to be the way that the statute is written, but that is the way USCIS has always interpreted it. They could easily interpret it a different way because it's still in line with the statute. We were hopeful that the Biden administration might take action on that, had a letter writing campaign for that. I don't think the Trump administration would be interested in that, but it's something that Congress would have to change as well. So yes, you can absolutely request that from your congressman, request that from USCIS to make that change so that more people, the workers, can actually receive the green cards.
Minus priority date is December 2022 in EB1C. Should I wait to apply for my college application, being in high school senior, so that I can get my GC this year? I'm assuming that you're a child. Your parents' EB1C priority date is 2022. You can apply for college admission, and a lot of fear is there among the people that if somebody moves to F1 visa, they cannot file as a dependent in the 485 application. That is not true. So, in the case where the parent's priority date is December 2022, they can't file the 485 application. The date is not current. If the children move to the F1, as long as they are under 21, under CSPA, they can file the 485 application, not a problem. Just because they moved on to F1 does not prohibit you to file a 485, but they have to be under 21 in the CSPA. There is a difference between under 21 and under 21 CSPA. CSPA adds some age sometimes. It depends on how long the I-140 has been pending. So if you don't know what that is, you may want to consult an immigration lawyer, but general rule is that if you are under 21, no matter whether the dependent is an F1 visa, they can still file the 485 with the parents.
Galila says, can an H-1B holder work outside the US for 1 year? The perm is in process. Yeah, I mean, if you're outside the US, you're not an H-1B holder, so you can do whatever you want, whatever's legal in the country where you are working. So if you're in your home country, I would assume you're able to work there. And you're not an H-1B holder, H-1B rules do not apply to you. Once your perm is at the 365 days, your employer can file an H-1B extension, consular processing, you get the visa stamp and come back in, no issues at all.
Camila wants, I want to have a green card. Well, I wish I could just cut a green card and give it to you. It's not, doesn't work that way, that I can buy a green paper or green card and cut into pieces and give it to you. It's not that. It's a very lengthy process. It depends on, there are many different ways you can get a green card: employment based, family based. There are a different lottery based also are there. So we have to look into which basis you're eligible, what are the criteria, how long it's going to take. And it's a whole 9 yards. It's not like going to a movie ticket or buying a Coca-Cola. I would say certainly it's very complex than buying a Coca-Cola.
Anand says, I moved on H1 from company A to company B, then I did a change of status to B2, back to H1B with company C. Have the visa stamped until March 2026, but with company A, can I travel to India and come back with the existing stamp? Yes, you do not need to have the stamp from the current H1B employer. It does not matter that that H-1B stamp has the old company's name on it or your old petition number on it. It does not matter that you did a B2 in between. When you're coming into the US, you need to show your visa stamp that is not expired and your current I-797 approval notice with a valid I-94 on it. Make sure that they give you the same I-94 end date that's on company C's approval, not on the visa stamp. Verify that before you leave the airport and make sure you get it corrected if they give you the shortened date.
My fiancée filed an H-1B extension recently. I'm an F1. Should we wait for her approval before going to India to marry, or is it better to marry in the USA while it's pending? One thing that we are noticing is that we are having problems, people getting stamping in India. We had so many couples that the guy was the person already F1 expired, the person has a job and got the H1B approval. They went for stamping. The H1B did not get stamping, so the H4 doesn't get stamping, and the both wife and husband are stuck in India. And this happens so frequently. I don't know whether all these people consult with me afterwards or what happens. I don't know, but I get a lot of these consultations every day. I get a lot of these people coming to my Zoom call. Oh, I am stuck in India. What do I do right now? So my simple question is that if your fiance is here and you are here in United States, why do you need to go to India to get married? Just get married here in United States and get that thing. I mean, I don't know India, how India is back in olden days, how we used to get married. Was take the girl, go to temple, or sometime go to registration office and get marriage. That's how we used to get married. And right now, I don't know. The intention is wife and husband has to be unity. Nothing to do with the family members, guys. You want to get united, just get married in United States and live happily ever after afterwards. You go there and you get stuck there, that's going to be a problem. Some get stuck there. Sometimes one guy gets stuck there. So don't create that problem for you. Don't create a problem for us. Don't create a problem for your society. Don't do just get married here in United States and file for H4 and live ever happily here in United States.
Pritam says, I'm interested in applying for a B2 tourist visa. Could you provide me with guidance on that? So, number one, you have to be coming to the US for the purpose of tourism. So, visiting family, visiting friends, visiting Disney World, going to the Statue of Liberty, whatever the case may be, but you need to be coming just for tourism purposes for a limited period of time, for a set specific limited period of time, for a temporary trip. You need to have a residence abroad that you intend to return to, that you don't intend to abandon, and you need to convince the officer that you are not an intending immigrant and that instead you will return back to the US. Do you have ties to your home country? Do you have a job there? Is your job letting you take this trip and you'll still have a job to come back to when you come back? Do you have property there? Do you have bank accounts there? How are you going to support yourself when you're in the US? All of those things are going to go into about a 2-minute visa interview with the consular officer, and they may ask 0 questions. They might just look at you and say no. They may ask some questions, and you need to make sure that you understand the purpose of the visa and that you are in line with that so that you can get that visa. But yeah, and it's also going to probably take a year to get because visa appointments are not available right now.
Question that is coming from Bhargav Madhimani is that H4EAD opening a company and wanting to retail store. There are different kinds of company. Rahul told you may want to check with the CPA on it, what is better for you. But however, sometimes they may be a little bit confused. So you can tell what I am telling you right now. There are typically two kinds of corporations, though. One is S corporation, one is C corporation. C corporation, your grandma in India can own shares in the C corporation. That those C corporations are mostly like Microsoft and all those companies are C corporations. So even small companies can be C corporations. But when it comes to the S corporation, only the residents of United States can be the shareholders of the S corporation. This is where the CPAs get confused, though. Does the H4 EAD person comes under a resident of United States or non-resident of United States? The H4 EAD person and H1B person, L1 person, L2 person, they do come under the residents of United States according to the definition of the IRS, Internal Revenue Service, though. Now, according to the immigration, it's a different definition, but they should not be looking into the immigration definition. They should be looking into the IRS definition. Now, if you are a resident, you will have to pay the Social Security taxes, which all the H4s, H1s, and L1s and L2s do pay Social Security. So, in the case you will come as a resident, so I tell them to open a S corporation, not a C corporation. That is the only advice I can give, though. Now, why does the S corporation, C corporation makes a difference is that when C corporation makes $100,000 profit, then they pay $20,000. And if you are the owner of the company, then you get the rest of the $80,000. You have to pay taxes on the $80,000. That means that you're paying two times the taxes. If it's a S corporation, the corporation pays zero taxes. And when you get the $100,000, you pay taxes on the 100,000. You only pay one-time tax. So that is the only advice that I can suggest to the CPA. What kind of corporations? S corporation. If the CPA has any questions, have them contact us. We'll answer them.
Blue says, if a US citizen child is turning 21, do they need to have an income in order to sponsor the green card for their parents? What's the processing time for this category of family-based application? They may not need to have an income depending on the situation. So if the parents that are being sponsored have an income and that income is lawfully obtained, meaning they have employment authorization, like they're on an H-1B and they've earned an income, you can use the income of the intending immigrant, which is the parent, in order to meet that requirement so that the 21-year-old child does not need to meet that income requirement. So that's quite common. Processing time is anywhere from 6 months to 2 years these days, just all over the board.
Okay. So
Deepika says, can we appeal in the courts to see if USCIS is correctly interpreting the fact that dependents should count towards the green card numerical limits? It's already been litigated and not successful. Basically, a court is not going to basically, the courts say that USCIS is the expert in determining and interpreting the statute issued by Congress. And so the way they've interpreted it is reasonable, and therefore the court is not going to change that. So it does need to come from either USCIS themselves or Congress.
Emily, question from um, Bhagwan. Any updates on the birthright citizenship right now? Based on my knowledge, right now, everybody who's born here in United States is eligible for the citizenship right now. We strongly recommend those who are getting born right now get their passport stamped. I'm sorry, apply for the passport immediately, apply for the birth certificate immediately, though. Now, there is a hearing in October, and it may go up to, we may get a decision by January of 2026. And after the Supreme Court gives a decision, we will figure it out how the things are going to turn at that point of time. Anything you are having any extra knowledge than what I have, Emily?
Nope. Nope. I think we just have a bunch of injunctions that will continue to be in place that allows everyone to be considered a citizen still.
What if somebody is in Texas? They can still get the citizenship, Emily?
Yep.
Okay, still get the passport and still get the birth certificate, guys. And all those people who are getting born, don't wait. Just get the birth certificate. Don't wait for the Supreme Court decision. Get birth certificate. Get the passport as soon as possible.
Srija says, how many times can we extend an H-1B after the 6 years during the perm process? There's no limit on it as long as the perm has been pending for over 365 days and continues to be pending. So you could do a 7th year extension once the perm hits 365 days. If for some reason it's still pending 6 months later, when it's time to extend again, you can file that extension based on the pending perm or even a pending I-140.
Muni Mahesh asked this question: is it good to travel outside the country with advance parole, which is valid for 3 more years? We have no problem, none whatsoever at all, for those people who have traveled in advance parole. And there are some rumors, some people have flouted. We never said that. that advanced parole has, and right now I'm telling you one thing, those are just rumors. The truth is that those people with advanced parole have no problem, none whatsoever at all, for them to travel and come back if the validity period is still there.
All right, we're about out of time, but I want to take this last question from Parag, who wants to know if there's any updates on people receiving NTAs due to 60-day grace period, H-1B transfer, change of status to H-4, B-2, and how those are going. So we've been monitoring this, and we are still getting reports of people getting the NTAs. But when we look into the documents, all of those NTAs were issued before July 30th. The most recent one that came to our attention was issued July 8th. And I mentioned July 30th because that is the date that the USCIS feedback informed me that they were raising the issue to their subject matter expert. So I'm hopeful that that is what caused them to stop issuing them. And then for those that have received them, we've gotten a lot of reports of people that were able to successfully terminate those proceedings, motion to dismiss the proceedings, and they're continuing in their H-1B status as they normally would. A lot of them are issued with dates very far in the future, sometimes into 2026. So those cases are still pending, but they should be able to be easily handled given that the NTA shouldn't have been issued in the first place.